Gotham Investigations, and I'm your host, Jeff Giordano, the scorned woman of Miami. Do you want to put your misery to an end? You're going to meet a family lawyer that was 1 degree away from being too smart to be on our show. Stay tuned. You're going to love this episode. This is Gotham Investigations. I'm your host, Jeff Giordano. We have a special guest on our show today. Yes, another Italian, Karen Lungarelli, a professional family lawyer. Karen graduated from Elon University with her bachelor's degree, a summa cum laude. In other words, she's a genius. She also obtained her master's degree in public administration from the University of New Hampshire. She graduated her law school with the University of Miami. She currently is listed as a super lawyer in the state of Florida, which, to claim that title, only 2.5% of the attorneys are allowed to use that claim. And she also sits on the Florida Supreme Court as a family mediator. Karen, welcome to our show.
Thank you, Jeff. Thank you for the introduction.
So we are in the Scorned Women of Miami, and we're going to have some future seasons with the Scorned Men of Miami, as well as a lot of cases that we handled with the LGBTQ community. We've handled a lot of cases together. Of course, the referrals and the compliments that we get from you is just tremendous, that you are the best attorney anyone has ever had. You put up with no nonsense. So let's start out on a relationship where an individual might be being mistreated and being hit, being violent, violent spouse. What can a person do to make themselves safe, first of all, and how can they move forward with a divorce, especially if the other party is refusing to do so?
Okay. Well, if there's an ongoing situation of violence, the first thing to do is always call the police. Obviously, that's your first step. If there's a situation where you are in fear for your life or physical safety, you always want to call the police and have them intervene. If you're not in immediate physical safety, you can go to the courthouse yourself and file for what's called a temporary domestic violence injunction. So that is a free service that the court does. You go to the courthouse, you get an injunction, the injunction will be in place automatically. In other words, you'll walk out of the courthouse with a piece of paper that has the temporary injunction on it. The law then requires a hearing within 15 days after that temporary injunction is issued. There'll be a hearing set within the next 2 weeks. Usually these are quick, short, 15-minute hearings. At that point in time, you're going to want to obtain counsel to represent you to make sure you're fully protected, make sure that there's no future danger or imminent fear of harm going forward. So at that first hearing, you're going to want to make sure you show up with counsel who can then speak to the judge and request a continuance. So you get a longer hearing, so you are able to put on all the facts and evidence that you need to present to the court. But the first and most important thing is always, if you're in immediate danger, in other words, there's an ongoing situation, you never want to hesitate to call the police. If the danger is not immediate and not happening at that moment, you can go to the courthouse. And it's really easy. You just walk in the courthouse, the front door, ask them, tell the individuals there at the courthouse you need to file for a domestic violence injunction, and they will point you in the right direction.
So we've noticed sometimes with being a police officer for 30 years that's very easy to throw that stuff out there, get a restraining order,
Right.
Get this, get that, but sometimes on certain violent offenders, it escalates them to the point where their anger is heightened and the violence is heightened. Do you ever have situations where you have taken them out of that environment and provided them with a safe house somewhere with the county?
Fortunately, no. I haven't had that direct situation. We have had situations where the individual does get more aggressive, does get more violent when you call the police. So there's always a fine balance there. If the situation is happening in the moment, that you would want to call the police, 9 times out of 10, they're going to actually be arrested right on the spot. If it is not occurring, then there is the tool, like I said, going to the courthouse, getting that injunction, they'll be served with it. So if they do show up, if they do violate that injunction, they can be found in contempt of court, and they can also be incarcerated, picked up. So if anyone does violate that injunction once it is in place, you can call the police. So always make sure you have a copy of that injunction with you, call the police, and then let the courts handle it. Don't try to outsmart the other person. Don't try to figure it out yourself. But that's why we have the courts. That's why we have these services that we provide to individuals. And that's also why, quite honestly, that first initial injunction is a free service offered through the courts. It's for your safety.
So when you graduated, you worked for this big, large law firm, correct? So you have experience on the large law firms that you've handled a lot of celebrities, you've handled a lot of athletes, professional athletes, and now you have your boutique family law business. If somebody wanted to get a hold of you for your services, what's the name of your website?
So my website, it's really easy to remember. It's my last name, Lungarelli Law. So www.lungarelli, that's LUNGARELLILAW.com. So LungarelliLaw.com.
And do you have an office number that they can reach?
Yes, I do. It's 305-998-3828.
And exactly what kind of family law do you practice? Can you list the different practices that you do?
So I like to kind of break it out to divorce and family law. So everyone knows what divorce is. That's, the primary area of focus for most matrimonial attorneys. So divorce, that's several different types. There's litigation, there's uncontested, there's collaborative. So we do all areas of divorce. And then the second part, the end, is what I consider the family law. So that would be prenuptial agreements, postnuptial agreements, contempt and enforcement. What that means is if someone's not doing what they've been ordered to do by the court. So if someone's not paying child support, someone's not paying alimony, someone's not refinancing the mortgage or participating in time sharing, that's when you would do what's called a post-judgment contempt and enforcement. We also do post-judgment modification. So if there's a substantial change in circumstances where the time sharing maybe with the minor children need to change, or the amount of alimony or child support needs to change, we do those post-judgment cases as well. Then smaller things like name changes, and another big one we do is we do adoptions and extended custody by family members as well.
Now, you're a very well-known attorney. You don't just work in the Brickell area. I want our viewers to know that you work throughout the state of Florida. You have cases in the Tampa area. You have cases in the Orlando area. You deal with high-end clients. But what resources are there out there, if any, for individuals that don't have enough money to retain you?
So for resources, you can go to the courthouse. There is you can go to the clerk of courts at the courthouse and you can get a packet and attempt to walk through it on your own. I would always advise at least having an attorney double check that packet, because I've seen some worst case scenarios where people go to the courthouse, they fill out the forms, they buy the packet, it's like $70, something like that for the packet. And then there are the filing fees, which are around $415, and they do all that, they complete it, and they never actually finalize it. So 3-4 years later, they think they've been divorced, but they never actually finalize it, because the clerk's just going to take those forms and file it and give you a case number, but they're not going to finish the case for you. So I'd always advise at least maybe paying an attorney for an hour or two to look through it, make sure that you're doing it the right way, that you know how best to move forward.
So this season, we have a lot of ladies that has hired Gotham Investigations to conduct investigations on their spouses, cohabitation cases that we'll get into as well, cases where they fear that there's violence on their child's behalf. But I always tell them on the family side, I want to deal with your attorney because Florida's actually a no-fault state, but some of these girls just want answers. Can you explain what a no-fault state is and how it really doesn't matter if you can have all the pictures in the world of your spouse fooling around?
Right. Well, what a no-fault state means is that anyone can file for divorce at any time for any reason, as long as they've been a resident of the state of Florida for 6 months or more. So again, anyone can file for divorce at any time for any reason, as long as they meet the residency requirements. Now, things like infidelity may be an issue going forward if you can show what's called a dissipation of marital assets. So if your spouse is having an affair with someone and they're having a regular and ongoing affair, and you can show they've spent substantial amounts of monies on trips and vacations and jewelry and gifts, those sort of things. But so I'm not saying it's completely irrelevant, but 9 times out of 10 it's not as important as most people think, which is a little bit harsh. But the good news is that you don't need to prove a reason to get divorced. If you want to get divorced in Florida, it is a no-fault state, so anyone can file for divorce.
How important is it these days in today's society with divorce rates the way they are to get a preempt? And can you explain what a preempt is and how that record is maintained? throughout the course of marriage?
Sure. A prenup is a good idea for anyone who is in a position where both parties are going to build their own individual assets or future wealth. So you're an attorney, and let's say your fiance is a doctor. Those two individuals may want to consider a prenuptial agreement because they're both in positions where they could accumulate individual assets, individual wealth, those sort of things. And if you do get divorced, two people with those type of positions could be very litigious, could be very expensive. So you're going to want to protect yourself and what you build in the future. That's the first type of people that I would recommend get a prenuptial agreement. Anyone who is going to build substantial assets or wealth going forward. The other one is, we all know that the general statistic is 50% of marriages end in divorce. Well, over 60% of second marriages end in divorce. So I'd also recommend people who are going into their second marriage, especially where there may be a difference between ages and assets, where one party may have acquired substantial wealth or assets years before even meeting their soon-to-be new spouse. So you're going to want to protect that, because the idea is that in Florida, there's what's called equitable distribution, which assumes the parties built something together. And when that's not the situation, where you have that imbalance, you want to make sure anything you acquired prior to the marriage stays safe and separate and apart. And that process, if it's done correctly, can save you not just a lot of time, not just a lot of money, but a lot of animosity, especially if you do have children during the marriage. So you're going to want to make sure that this prenuptial agreement is done correctly and that you can actually use it as a substitute for a marital settlement agreement. Whereas on the opposite end, if you work with someone who doesn't really know what they're doing, the prenuptial agreement's maybe not done correctly, it can actually cost you more time and more money, because someone's going to challenge it. You're first going to have to defend the prenuptial agreement. And then once that's done, once you're done either defending it or challenging it, then you go forward with the divorce. So a properly done prenup can save you time and money, whereas a poorly done one will end up costing you more time and more money.
So that kind of supersedes alimony payments and stuff if you have, hey, I have this paper here.
It does supersede it, as long as there are provisions. They're supposed to be fair and somewhat reasonable under the circumstances, right? So you can't have a spouse worth $20, $30, $40 million, and the other spouse, if they get divorced in 10 years, gets nothing. Typically, there's going to be some sort of buyout provision, right? So both sides are protected. And you can't contract for children, so because you don't know what's going to be in the best interest of the children, but you can do other creative things, like if you get divorced while the children are still minors, the spouse with lesser access to wealth will be able to remain in the marital home until the children emancipate. So there are ways to protect both sides. That's the idea.
What's the time frame in a divorce settlement if one party is in total disagreement and wants to carry this thing on and just refuses to get a divorce, or maybe bails to another county in northern Florida or another state?
Jeff, it's as quick as the slowest party. So what I mean by that is it can go on for years. I've had some people who were married for 5 years, and 7 years later they're still fighting, right? So if someone wants to make it difficult, they can make it difficult. And that's not good for families. That's not how lawyers should practice, but sometimes there are clients out there and there are individuals who just keep fighting and keep pushing. And even after the divorce is finalized, after you get that final judgment and you go have your divorce party, I'm divorced, final judgment, people often continue to fight after the fact. So it really benefits the clients and the families to do this as amicably as possible.
And I'm sure it benefits the attorneys for them not to do it as quick as possible.
Well, in that situation, the only people who
win...
Or
the private investigator as well.
Yeah. In those situations, the only people who win are the attorneys, right?
Yes, that's for sure. I mean, I've had clients say that they went into the hundreds of thousands of dollars in attorney's fees, but they have large assets, large houses, large boats.
Yeah.
And it's just...
Yeah, and there is a difference. So when someone has in a state that's of a substantial size, you don't want to be jumping over dollars to pick up pennies, right? You want to spend the time and the money to do it right. You want to spend the time on attorneys who know what they're doing. You want to hire qualified forensic accountants. You want to hire a qualified private investigator. So you're going to want to spend the time and the money to do it correctly, because once you're done with it, especially when it comes to division of assets, that's done. The court does not reserve jurisdiction to go back and remodify your division of assets. Unless there's fraud or some other newly discovered evidence after the fact, very rarely can you actually go back and undo that settlement agreement. So you want to spend the time and the money to do it correctly up front, because you're not going to get a second bite out of the apple.
I see more and more on more of these cases that we work with yourself and other attorneys that the opposing counsel is automatically filing a motion to obtain all the private investigator documents, whether you have one or whether you don't. They're kind of like just throwing out the line and fishing. What do you recommend for someone like myself to some of these attorneys that we hire outside and are in like, we have time frames? Do you recommend releasing those reports at the end of the investigation rather than in a timely fashion? That way they don't have anything that they have to present on the
So
motion?
do you mean if you're served individually with a subpoena, or if the attorney receives a request for production?
It's a request for production that they usually do, and they usually include a private investigator in their reports on there. Whether they know they have one or they don't,
Right.
it's kind of like common practice now that they're doing that.
Well, typically, if you're not sure you want to use the private investigator or you want to use their report, you would object to that, but reserve the right to amend. So what that means is you're not required in any area for any type of expert, even if you hire a financial expert or you hire a private investigator, you're not required to turn over those experts' reports and materials unless you intend to use them in court. If you don't intend to use them in court, that's considered work product, that's considered attorney work product, and that would remain privileged and confidential, so you do not need to turn those over. So you should always object to those until you make a final decision, and reserve the right to amend your response, but always object to it. And you can object for attorney-client privilege, you can object to discovery is ongoing, and reserve your right to amend. That way you can make that final decision about how much you want to use and if you even want to use it.
So on a case where a family does not have children, a husband and wife, is there a time frame living together that alimony would kick in for the other party that's making more than the other individual?
There's several different types of alimony, so it depends is the answer, right? So under Florida law, a marriage of 7 years or less than 7 years rather, is considered a short-term marriage. 7 to 17 years is considered moderate term, and 17 years and more is considered a long-term marriage. So why do I say that? Because there are different types of alimony depending on the situation of your marriage, depending on the financial need and the ability and the length of the marriage. So a short-term marriage is going to have a shorter period of alimony, and it's most likely going to be less modifiable than a long-term marriage where there is what's called permanent alimony that is always modifiable depending on a change in circumstances and a change in something that would unanticipated future events, like maybe someone loses their job and is unable to find a job despite their best efforts, or there's an illness or an injury. So you could always modify permanent, whereas a shorter term alimony award, such as maybe bridge the gap, which cannot exceed 2 years, usually that's going to be non-modifiable, and that's for a shorter length marriage.
So what about like the spouse that's approaching that 7-year mark, and he realizes that the first level, the first plateau, and he realizes my spouse is a scammer, I want out, files for a divorce, but now of course the other spouse is going to be like the dairy creamer, the milker, trying to get to that 7 years. Is it from the time you file that the judge will look at it, he never reached the 7 years, or how does that work?
So 7 years is not what we call a bright line, right? So 7 years is more of a recommendation. So even at 7 years or at 5 years or 6 years, you can have what's called durational alimony, which is typically from half the length of the marriage, but cannot exceed the length of the marriage. So if you're married for 6.5 years, you can have an alimony term from anywhere from a couple months to 2 years to 6.5 years. The big differences and what people get worried about is permanent alimony. So that's going to be 17 years or more, right? So that's the big one, is if you walk into court and you've been married for more than 17 years, it's very unlikely that you're going to have anything other than permanent alimony. Because of the length of your marriage. And so what you want to focus on is, your 16 years, 16 and a half years, 15 years. Those are the years where, as you said, if you think your spouse is a scammer or they're going to try to hang in there to get a little extra money, you want to make sure you file before you're stuck with permanent alimony.
So we have a book that's out, The Mitigation of Mark Seaver's Till Death Do Us Part. It's available on Amazon and will be on Kindle also as well. You acknowledged the book and
Yeah.
gave us a wonderful acknowledgement.
Thank
you
you.
for that. But in that particular case, it was a horrific murder for hire where the husband murdered his wife. And the pre-planning stages, they had it set up of what would happen in the course of death of one of the spouses who would get the kids. Do you do like some probate as far as setting up trust accounts for families, and how important is it for a family with kids to have monies and stuff set up for them?
Right. Well, first of all, I never recommend anyone hire someone to kill their spouse. I'm just joking. So for setting up, I do set up basic end-of-life documents. So a will, a last and testament, anything like that, but I don't set up trust. So that's a completely different area. I have some
But
other
you have
attorneys-
experts that work in
Yes.
your office that do that,
Yes,
so if somebody
yes.
were to need a trust, they can call you.
Correct.
And you
Correct. So
you
I
set 'em up.
focus on the litigation and the family law and the divorce, where if someone needed a trust set up for wealth or generational wealth to protect their assets, to protect their future generations, then certainly we can set them up with someone in our office who would assist them in preparing those documents.
So child custody, is there a difference between a mother who has, say, a child in wedlock that's not married, custody versus custody if somebody is married and they have a child?
Yeah, so there are a couple different concepts. So there's paternity and then there's custody. And just because you have one doesn't mean you necessarily have the other. So a child born outside of wedlock, the only natural guardian is the mother. So if a couple has a child and they're not married, the only parent or the only individual with rights to that child is the mother. And even if the father is successful in establishing his paternity, and there's a couple ways to do that, whether it's through court order or acknowledgement signed under oath by both parties in front of two witnesses, that still doesn't mean there is an order on time sharing. Or even if the Department of Revenue can establish paternity and child support, they can't establish time sharing. So if you have paternity established, that doesn't necessarily give you the right to access to the minor child. So you would still need to go that second step and do what's called establishing a custody plan, a time sharing plan, and make sure that you have right to access to the child, because without that, the mother, who is the only parent with right to the child, can leave the state, can leave the area, and can take that child wherever she wants. Whereas if a child's born during marriage, then both parents are assumed the legal fathers, the child is assumed legitimate, and both parents have right to access in time with that child.
So I've had it numerous occasions, wealthy clients that we deal with as well, that it's kind of, it all boils down to a custody dispute at the end. And why are, on the father side, because these usually who I get are the women clients, why are they so adamant in getting that 50-50 percentage of being able to have their child? Because we followed the husbands around and are not even with the kids, they have a nanny, and it's kind of like they don't want to pay the full child support. Is that what's behind that?
You know, it could be, Jeff. I will say this, child support's not the big numbers people think it is, unless we're talking professional athletes or people who make several million a year, 5-10 million a year. Child support's not going to be a big number.
Well, I tend to disagree with that, Karen. I mean, I was a police officer, and I've seen many officers, not myself, thank God, go down at the hands of child support, like $1,000 per child, and I even have judges that came back and says they stopped working off duties for that point. I can't show I'm making all this money because of my children, and the judge says, you've made it last year, you have the ability to make that off-duty money this year. So it is an impact on people's wallets and pockets.
It is an impact on people's wallets, but at the end of the day, child support's always going to be less than alimony, right? Child support's always going to be less than dividing your assets. Child support's always going to be less than paying the attorney's fees to do it the right way. And if some of your buddies are stuck with those horrific child support numbers, perhaps they should call a qualified family law attorney to see what they can do about redoing that number.
Absolutely. I'll put your name up at the police station as early as this evening.
Yeah.
I'm sure you'll get many calls.
I will be looking for the calls.
So how do you, what advice do you give people out there when they're getting married? What advice do you give them to have a happy relationship and move forward where they don't have to have somebody like yourself for services, because the percentages out there just ain't working. It seems like everyone's, everyone is getting a divorce sooner or later.
Well, I certainly don't think I'm qualified to be a relationship expert, but I can tell you the 3 reasons why marriages fall apart. The first one is intimacy. The second one is money, finances, and the third one is children, right? So 2 of those are really easy to deal with. Money, finances. You can have that conversation before you get married. You can make sure you know the person you're going to get married to. How do they spend? What are their habits? Are they savers? Are they spenders? Do they live within their means? Do they live beyond their means? And talk about how you're going to cover your expenses during the marriage before actually getting married. And that's one good thing about doing a prenup, not to go back to what we've already discussed, but when we do a prenup in our office, we give our clients a letter that says, talk about these things. Here are some very specific financial conversations you should have with your soon-to-be spouse. So money is one that can be handled. Same with children. Make sure you know how the other person views child rearing and raising of children and what their beliefs are, whether it's educational, religion. Are you guys going to be on the same page? Because children are very stressful and they can tear couples apart. So unless you guys are a team and you have the same understanding about how you're going to raise your children, that can ultimately destroy your marriage as well.
A lot of good advice I see, because you've been there, done that with so many clients across the board. And somebody getting a divorce with their children, I've seen it as a police officer, drug addicts on the street, prostitutes, and they give the custody back to their child. Is this something that judges don't take them away, put them in a foster home that quick, unless there's really some outrageous reason to do so?
You mean if a drug addict has their child? Or?
Correct, yeah.
Correct. Well, that would be a Department of Children and Families
Which
issue.
they're useless.
They're overworked. They're understaffed. They're underpaid. Department of Children and Families, yeah. So if there is a drug addict or someone who should not have their children, then that's the job of the Department of Children and Families. In other situations, what we often do is we would file emergency motions to immediately suspend time sharing and to ask for a psychological evaluation. And if their mental health is not the issue, if there's a drug issue, we can ask for drug testing, we can ask for drug screening, we can ask for home studies, a bunch of different factors to be put in place that can protect the minor children. So the family courts are not required to, if they do suspend someone's time sharing because of drug use or because of ongoing domestic violence or because of less than stellar behavior, whatever the reason may be. There's a bunch of reasons why they may suspend someone's time sharing for the best interest of the children. The courts are no longer required to add a plan in the final judgment. And what do I mean by that? By a plan, the courts used to say, okay, mom, if you can get clean for 6 months, then you can start seeing your child this many days. And if you can stay clean for another 3 months, then you can start having overnights. The court's not required to do that anymore. They can suspend the time sharing, that's it, final judgment signed, order signed, have a nice day. And then if the parent whose time sharing is suspended, it's their responsibility to come back to the court and prove, hey, I've rehabilitated myself as a parent. I've done the stuff you've ordered me to do. I've gone to the anger management. I've gone to the AA meetings. I'm in a better place. I have a stable job. I have a home. Start giving me time with my child. So that's another benefit, that the courts no longer are required to include that plan to regain access to your kid. They're required to include a plan to get services, but not an automatic regaining of access to your child.
Now, have you ever represented both the husband and the wife that come in and they just want an amicable divorce?
Absolutely not. You're actually not permitted to do that under the Florida bar. Why? Because they have 2 conflicting interests. What we have done is we've had one spouse come in and they say it's amicable, and we'll advise them that we can prepare the paperwork, but we're going to be your lawyer. We're going to answer your questions. We're going to give you advice. If the other spouse has a question, we can't give them legal advice. We can listen to them and then relay their response to our client, but you certainly can't advise. You can't represent 2 parties whose interests are conflicting.
And people don't realize also that there's really no immediate time frame if you have the other party that's kind of like still a little iffy, asking for a lot of things. What's like a basic time frame of a client that comes in, wants a divorce, middle class, higher assets, maybe the upper class? Is there like a chart that's in mediation that says this is how it's divided, where there's no outrageous claims on the other side when it gets down to it, or no?
No, I mean, the courts start with the presumption of assets being equal, and then any deviating factors need to be considered from there. So in mediation, people, assuming everything is pretty straightforward, there's assets that need to be divided, no one's saying there's any portion of it is premarital, no one's claiming any dissipation, everything's fairly straightforward. What one party wants may be completely different than what the other party wants. So, you know, maybe this party really, really wants the house for whatever reason, and maybe this party says, well, I don't want the house, I want the retirement accounts. That's a good thing, because you can, in mediation, reach an agreement, negotiate, really find what people's bottom lines are, what their wants and their needs are, versus saying, here's a chart, this is how it's happening, good luck. So it is supposed to be a court of equity, and it's supposed to be driven by the clients and giving the clients the opportunity to have those conversations with their lawyers. If you're in mediation, have those conversations with the mediator, and the mediator can facilitate what one party wants versus what the other party wants, and hopefully get to an agreement that, you know, you're not going to get everything you want, but it works for both of you.
How much do you use and how effective are forensic accountants in your practice?
We use them quite a bit, and they're very effective, especially where there's a question about the valuation of assets, where there's a question about alimony, where there's a question about ability to pay alimony, for those type of things. It's always good to have an expert, because at the end of the day, if you go to trial, a judge is going to sit there, and as an attorney, I can't give an opinion about what I think the marital assets are worth, because I'm not qualified to do that. So if you have a state with assets, if you have a state with value, if you have questions about marital versus non-marital assets, you're going to want to get a forensic. If you have a case where there's alimony, that is something where you may also want to, depending on the size of the alimony you're seeking or the size of the alimony you're trying to defend against paying, you may also want to get a forensic to look at the income, look at the expenses, do an analysis of the lifestyle and what the actual need and ability is to pay.
So I think you have 4 words that you could give to our women clients that we had moaning and groaning on our show. And if you could describe this in 4 words, why are divorces so expensive?
Because they're worth it.
Gotham Investigations, your family attorney, Karen Lungarelli. We're going to have her on future shows. It was fantastic. You were a wealth of information, and thank you.
Thank you, Jeff. It was a pleasure being here. I look forward to coming back again.
The episode with Karen Lungarelli, the family law attorney, was filmed in front of a live studio audience. We hope you enjoyed this season of The Scorned Women of Miami. Subscribe, hit the like button, or you might be the next one we investigate. GothamInvestigations.us.